Thank you so much for joining us today at the latest in our series of live webinars from the Product Liability Group at 2 Temple Gardens. Just a quick reminder to everybody joining us, if you could please ensure that your screen and the camera's not sharing and that you are on mute, that would be wonderful. This afternoon, in the course of the next 35 minutes or so, myself and my colleague Andrew are going to share with you some practical tips that we found useful for bringing and defending product liability claims. I'm going to begin by looking at two areas, pleadings and expert evidence, and my colleague Andrew is then going to take over and look at GLOs and matters of settlement and costs that arise in group claims. In terms of pleadings, over the years, the courts have really encouraged the parties to try and find the right balance between, on the one hand, properly setting out the parameters of your case, and on the other hand, avoiding overly onerous applications for further particulars where they're not reasonably required. The importance of pleadings in modern litigation is clear. As stated by Lord Wolfe, McPhilmy and Times, pleadings are still required to make out the parameters of the case that is being advanced by each party. In particular, they are still critical to identify the issues and the extent of the dispute between the parties. What is important is that the pleadings should make clear the general nature of the case of the pleader. Now, two really important points flow from this. The first is, particularly with a product claim, the importance and the role of the pleadings is to allow the court and the parties to discern what is in dispute in terms of the issues that are to be decided. And that then must govern the nature and the extent of the evidence that needs to be called at trial. The second point is that because of this, pleadings should be of paramount concern to the whole legal team, and they really should be a collaborative process and not something solely determined by counsel. As it's the solicitor who does all the important day-to-day conduct work on any file, and the pleadings permeate and govern all aspects of this, it's vital that solicitors too are up to speed on the requirements for the pleadings. This has a particular importance when dealing with claims arising from medical products, where the product under consideration is usually an inherently risky product with no guarantees of safety. In such cases, the defect often isn't apparent as, say, a case where a washing machine bursts into flames, so that careful pleading and proper expert evidence to establish the defect is required. There are therefore two very important questions to answer when identifying whether there is a viable product liability claim in respect of a medical product. First, what is the defect complained of? In other words, why is the product under consideration not as safe as persons are generally entitled to expect? And secondly, how will you plead that defect? Now, there are two relatively recent decisions that emphasize the importance of these issues of pleadings and remind parties of the need for care when pleading their case. The first is the case of G, which was the metal-on-metal hip litigation that came before Mrs. Justice Andrews. One of the ways in which the claim was put was that the prostheses were defective because they had a propensity to cause ARMD. This case was rejected as untenable in circumstances where at the time the product was put into circulation, it was known that all hip prostheses would shed debris, that all metal-on-metal bearings would produce debris, and that ARMD would cause the prosthesis to fail. Mrs. Justice Andrews accepted that safety is always a relative concept and that no product can be absolutely safe. In particular, she held that the public is not entitled to expect that a product which is known to have an inherently harmful or potentially harmful characteristic will not cause that harm, especially if, as in that case, the product could not be used for its intended purpose without incurring the risk of that harm materializing. The claimant's approach on the pleadings was to effectively ask the court to look at a known harmful characteristic of a product and to consider whether the pleaded circumstances meant in that case the harmful characteristic was a defect, and the court said that approach was impermissible. So the lesson we can take from that in terms of pleadings is that the claimant cannot simply plead a known risk of a product renders the same defective without more. Further, in terms of expert evidence, if a claimant wants to successfully establish defect, they will need to call evidence to say that there is either something in the incidence of the risk or in the way in which it occurred or manifested itself in a particular case that meant that product was unsafe. If the evidence only goes so far as to support the fact that the risk eventuated, this will be insufficient to make the claimant's case. In other words, if the claimant wants to establish a defect in a medical product case, they need to plead and prove something other than a known risk of the product. The importance of pleadings in this area was further emphasised in Bailey and others and GlaxoSmithKline. The claimants were individuals that had been prescribed Seroxat, a prescription-only antidepressant, which is one of a group of medicines known as SRRIs. The procedural background to the litigation was somewhat convoluted. The particulars of claim were drafted in 2007, and they described the defect as the capacity of the product to cause adverse consequences upon or following discontinuance, which were such so as to prevent or make more difficult the ability of users to discontinue, withdraw from, or remain free from taking the product to an extent that was greater than it was with other SRRIs. Now, before finalising its defence, the defendant asked the claimant to clarify whether, when contending Seroxat was defective, it was their case that the benefits of the product against other SRIs were to be taken into account. And the claimant, in their reply to the party team, confirmed it was not. Relying upon this, the defendants entered a defence that attacked the claim on two grounds. Firstly, they took issue with the claimant's whole approach to the issue of defect. In particular, they denied that it was right to ignore the risk profile more generally. They said, where you're looking at medicines, it's important that you compare the risk-benefit profile on the whole, and that's the only way there can be a proper comparison between the medicines to look at those relative risks and benefits. The second limb of their challenge to the claim was that they denied that in fact Seroxat was associated with the capacity to cause the adverse effects on discontinuance that had been alleged. A GLO was duly made in 2008, and 11 common issues of fact and law were identified. Initially, the case had been due to come on for trial in February 2011, but funding for the claim was withdrawn on merits basis. The matter was then stayed until 2015, when it came before Mr. Justice Foskett, who said that he would allow the case to proceed, but only on the basis of the case as pleaded at the time of the vacated trial. And when giving his judgment on this point, importantly, Mr. Justice Foskett set out his analysis of the pleadings and the respective cases of the parties. He said that essentially the claimant was running the case on the basis that Seroxat was the worst in class in terms of its discontinuance symptoms. And none of this was ever challenged by the claimants. Matters moved on, and Mrs. Justice Lambert was eventually appointed trial judge, and the matter was set down for a lengthy trial that began on the 29th of April last year. Unfortunately, an interesting issue arose in opening. When opening their case, the claimant stated that when determining whether the safety of Seroxat was such as persons generally are entitled to expect, the court had to assume that Seroxat had no relative benefits when compared to other drugs in an appropriate comparator class. In other words, the court had to assume a level playing field of risk and benefit as between the drugs in the appropriate comparator class, save for the single product characteristic of Seroxat that was alleged to have constituted the defect. The defendant immediately objected, stating that this case was not the basis on which the claim had been put. The claim had been put on the basis that Seroxat was worst in class in terms of discontinuation symptoms, and it was not now open to the claimant to argue that other risks and benefits of Seroxat could be taken into account. Mrs. Justice Lambert had to decide this issue at the outset, and she agreed with the defendant's arguments, noting that the pleaded case did not invite a holistic assessment of risks and benefits across drugs in the group, and that the pleadings had been analysed with due care and the nature of the case had already been determined, and there was no appeal to those earlier rulings. As to the claimant's argument that the defendant could have pleaded the benefits of its product, but that in not doing so, it had conceded that there were no relative benefits, the judge pointed out that the defendant was entitled to respond to the case as put, and that by deciding not to advance a positive case on benefits, this did not mean that the defendant conceded its product had no benefits. On the contrary, the judge held that once the claimant had made their approach clear, the defendant was entitled to respond to the case as pleaded. She pointed out that whilst the defendant could have opted to plead a further and alternative case as to the benefits of the product, it was absolutely under no obligation to do so. And whilst this was a risky strategy perhaps, it was one that the defendant was perfectly entitled to adopt. In terms of the claimant's suggestion that if the defendant's challenge in that case had simply been to their approach, then the appropriate way forward would have been for the defendant either to apply for strikeout or summary judgment, the judge held there was no obligation to do so. And finally, the claimant argued that as the matter had progressed, evidence had emerged that showed Seroxat had no particular benefit over and above the other drugs, the court was allowed to take heed of that evidence at trial. The judge again rejected this argument because she preferred the defendant's submission that had this been an issue from the start, there was lots of evidence that wasn't before the court that would have been called and that would have been necessary to determine that issue. Understandably, given the value and importance of the case, the claimants appealed, and the appeal was actually heard very quickly. In terms of the appeal, there were essentially three grounds. Firstly, they said that the argument was in fact open to them on the pleadings. Secondly, they tried to argue that the Part 18 response, where they had said that benefits and risks were to be left out of account, couldn't limit the scope of the case. And thirdly, as to the failure to appeal the earlier judgment of Mr. Justice Foskett, they said that the importance of his judgment had been overblown and erroneously misinterpreted, so it wasn't incumbent upon them to do so. The defendant said that really the court should address that third ground first, because if the claimant failed on that, the other grounds were hopeless. The Court of Appeal agreed not only with the approach advocated by the defendant, but also agreed with the defendant's argument. The Court of Appeal said the judge, namely Mr. Justice Foskett, had made clear what he saw was the ambit of the pleaded case, and importantly, he had then used that to make determinations about the ambit of expert evidence, listed the issues to be determined at trial, and set out how the case was to be managed. Against the background of his unappealed prior rulings on this, the claimant's attempt to raise a risk-benefit case was clearly impermissible. It would require a wide-ranging, factual and expert inquiry that had not been carried out by either party. So what lessons can we take from that? Well, the first practical tip is that claimants need to be very clear what it is they rely on to establish a defect in a product and to plead all the relevant circumstances which they say goes to the same. If you are a defendant and you receive the particulars and you are unclear as to what the claimant's case is, it's a good idea to raise Part 18 requests at an early stage and set out what you understand to be the ambit of the case you are responding to. Then in terms of case management, in anticipation of the first CCMC, it's worthwhile drawing up a joint list of issues so that both parties can be clear as to the exact remit of any dispute. If there's any ambiguity on that, ask the judge to determine this at the CCMC. And once you have his or her decision, consider whether you agree with it. If you don't, you will either need to appeal that decision or you will need to make an application to amend your pleadings so that they accurately reflect the issues you want to raise. Importantly, and this is a tip that I find once you get to trial really comes to the fore, you've then got to ensure that disclosure, witness evidence and expert evidence is limited to those issues that are actually in dispute. All too often, very grumpy judges complain at the reams of paper that have been produced in product claims, when in fact only 5 or 6 of the documents are relevant. So always bear in mind that you only have to give disclosure relevant to the issues in the case. And a final note for defendants goes back to a point raised by Mrs. Justice Lambert in the GlaxoSmithKline case. She said that whilst the defendant was entitled simply to challenge the legal basis on which the claim was put, it did run a risk in that it hadn't pleaded an alternative case in the event the court preferred the claimant's legal submissions. Again, this is a perfectly legitimate strategy, but as a defendant, you'll want to make an informed decision about whether or not it's a strategy you should adopt. And the only way you can do that is to get expert evidence to test the points that the claimant would raise and decide whether or not you want to plead it. Just finally then, before handing over to Andrew, I want to briefly touch on some matters of expert evidence. The first point is about identifying the right experts. All too often in product liability claims, in particular those involving medical products, parties want to adduce evidence from a medical expert in a given field who can offer no true expertise in relation to the question of defect. For example, whilst instincts may be to instruct an ophthalmologist alone in a case concerning defective lenses, if in fact the criticism is about the incidence of occurrence of a certain problem, then an epidemiologist may be of more use. Moreover, if the complaint is that in a particular case, the way in which something was manufactured or the way in which it was stored rendered the product defective, then a materials expert will be required. So you need to give careful thought to identify the correct expert. One issue that parties often face in cases like this is that the judge at the CCMC is often very reluctant to give permission for experts, and they want to limit expert evidence. But if you adopt the approach I recommended earlier in terms of coming up with an agreed list of issues, it will be much easier to argue that you should be allowed your expert evidence, because you can readily point the judge to the specific issue that expert evidence is reasonably necessary to determine. But I think that's enough from me for now, so I will hand over to Andrew.
Good afternoon, everybody. My name's Andrew Bershadski. I'm going to be talking about some of the practical aspects of managing group litigation orders. There are a number of features of group litigation which make it different from ordinary litigation and which mean that it needs to be managed in a slightly different way. Firstly is the large number of claimants that are always by definition involved in a GLO. There's no minimum or maximum number for a GLO, but ordinarily a GLO will only be considered by a court where there is a very large number of claimants. As a result of how many claimants there is often a far less close relationship between solicitors acting for claimants and their clients compared with ordinary litigation, and that can give rise to problems. Thirdly, there's often lots of sets of solicitors involved in group litigation, and that can give rise to problems in relationship breakdowns between solicitors that don't arise in the same way in ordinary litigation. Fourthly, the civil procedure rules actually don't make very much provision for what's to happen to costs in group litigation, and therefore there is a far greater emphasis on court orders in this important aspect. And finally, the costs involved in group litigation are normally far higher than would be the case in ordinary litigation, again changing the dynamics at play in trying to resolve this type of litigation. So the first thing I'm going to talk about is the kinds of issues that can crop up and cause problems in group litigation. Firstly, as a result of the fact that claimant solicitors often don't have as close a relationship with their clients as in other types of litigation, sometimes problems can arise when, for example, a client has died and that information hasn't been communicated to a set of solicitors, and that can happen very easily in very large claims. And a claimant is tried to be added to a group register or a claim issued on their behalf when it wasn't known or appreciated that in fact the client had died. And an important case of Kimathi demonstrates that in that situation the adding of a party who was in fact deceased is a complete nullity and not something that can be cured under any of the civil procedure rules. So it's an important thing to be aware of. But it's equally important to be aware that if that does happen, all is not necessarily lost. And the case of Tata Steel says that it is possible to issue a claim in the correct way in the future, i.e. by a dependent or as the personal representative of the estate of a deceased party, and that a second claim is possible to be issued without it being automatically an abusive process. Another thing that will often arise is that possible claimants will miss cut-off dates which are imposed by GLOs, and a number of cases have made clear that Rule 3.9, the relief from sanctions provision, applies to that sort of situation, so that it can be very difficult to add claimants to a group register after the cut-off date has been missed. However, the case of Taylor and Nugent illustrates that, again, all is not necessarily lost in that sort of situation, and that it is possible to issue a claim which relates to the same sorts of issues that are being covered under a GLO, but outside the GLO. That, again, a claimant is entitled to do that. It isn't an abusive process to do that. But the case also says that the court will manage any such claim having regard to the GLO that is proceeding. So any claims issued outside the GLO might be stayed, and bespoke costs provisions might be attached to them. So next I'm going to talk a little bit about settlement of GLOs and the kinds of issues that arise. Now, GLOs are particularly amenable, in my view, to being settled via call-to-bank offers, that is, via bespoke offers outside the provisions of Part 36 of the rules. And there are a number of reasons for why. Call-to-bank offers are far more flexible than Part 36 offers, and they allow claimants and defendants to come to an agreement which covers all the various important elements of the case to them. And the sorts of particular issues that one will want to be thinking about in a GLO which one wants to settle by way of a call-to-bank offer is firstly confidentiality clauses and agreed statement clauses, and that of course can be particularly important for reputational reasons in product liability group litigation. And secondly, some thought needs to be given in GLO situations as to how an agreement will actually become binding. The reason for that is that different claimants might take different views as to how good a settlement is, and therefore thought needs to be given to what will happen if some of the claimant cohort don't wish to settle. And an ordinary way to deal with that sort of situation is by introducing a threshold figure, for example 70 or 90% of the claimant cohort, which would need to be achieved in order for the agreement to become binding. And then if there are any claimants who don't want to be bound by the offer, then various provisions can be included in a settlement agreement, for example preventing the current sets of solicitors from continuing to act for those claimants, or from acting in any claims that raise the same issues for a period of time, such that the litigation can be effectively brought to an end in that sort of circumstance. And another important thing to remember when entering into any kind of settlement, whether by way of Part 36 or under a call-to-bank offer in group litigation, is that if there are any infants who are part of the claimant cohort, then the court will need to give approval to that agreement under Part 21. So one will need to justify, if there is, for example, a global settlement on behalf of thousands of claimants, it will need to be justified eventually to the court and explained what amount any infants will actually be receiving out of that settlement, how that's been calculated, and why it's reasonable, taking into account all of the liability and quantum issues in a claim. Group litigation is an area which is particularly amenable to settlement via alternative ways outside litigation. And the reason for that is the very high costs that are often involved in group litigation, and sometimes the relatively modest amounts of damages involved. And what no party involved in such a case wants to see is a situation where ultimately the costs of an action are so high that there's hardly any money left in the pot, whether it's a corporate pot or an insurance policy left out to actually pay out any claimants. And so on a number of occasions, bespoke mechanisms have been used by all the lawyers involved in these sorts of cases to achieve a more advantageous outcome for claimants. So, for example, a number of cases arose out of the Jimmy Savile affair, and the assets of Jimmy Savile's estate were such that it made far more sense for a bespoke settlement mechanism to be created, whereby a specific claim form would be filled out and there would be a panel of lawyers who would determine whether a claim would be likely to succeed in ordinary civil litigation, and a discounted amount of damages was paid out. Now, that enabled far more claimants to actually have some damages as a result of the abuse by Jimmy Savile than would have been the case if a full group litigation, civil litigation process commenced. Particular thought needs to be given at the outset of a group litigation action as to how settlements and discontinuances, that is, individual settlements and discontinuances, will be dealt with. And the reason that thought needs to be given to that is that the civil procedure rules don't actually provide a mechanism for determining precisely what costs will be payable upon settlement or discontinuance. There is a specific rule in Part 46, Rule 46.6, but it's very limited in its scope. It applies only to GLOs, but it's essentially a rule that makes some definitions, but it does not cover all eventualities, and specifically it doesn't provide for what will happen if during the lifetime of a GLO a case settles or is discontinued. Accordingly, some standard forms of wording for case management orders have been developed and approved, in fact, by the Court of Appeal in a case called Sayers and Smithkline, also a case known as Africa and Cape. And those provisions basically provide as follows: that if a claim is settled on terms that the defendant will pay that claimant's costs, then that means that the defendant must pay the individual costs relating to that claim, but also to a proportionate share of the common costs which apply to that claim. Whereas in the case of a discontinuance, whilst the claimant will have to pay individual costs relating to his or her claim to the defendant, liability for common costs is determined at the end of the trial. And the Court of Appeal explained in Sayers and Smithkline that the reason for that is if parties are settling a case, they'll be able to take into consideration the costs aspect of that. Whereas if a party unilaterally discontinues, then it won't know precisely what will happen to its costs, and therefore it's fair to leave common costs to the end of the trial. But it's also important to note that because these aren't rules which are contained in the CPR, they are instead model provisions, that they aren't necessarily the provisions which need to govern a group litigation order. And an example of different provisions with different results is in the case of Calma and African Minerals that I was involved with last year. In that case, the case management order provided that if a case is settled, then the defendant will pay that settling party's individual costs, but that liability for common costs will be determined at the end of the trial. Now, in Calma, 101 out of 142 claimants accepted Part 36 offers, and therefore the defendant was liable to pay the individual costs relating to their claims. For example, medical evidence that was obtained only in relation to those individuals. But the remaining claimants fought the case, and the defendant won at trial. The claimants argued, or the ones who had settled their cases, that look, because they'd been settled under Part 36 principles, the defendant needs to pay us our costs, and that includes the individual costs and the common costs that related to our claim, so roughly 2/3 of the claim. And the defendant argued, well, no, that isn't right, because the case management order provided that in the case of a settler, liability for common costs will be determined at the end of the trial. And since the defendant had won on all points and none of the lead claims had succeeded, there was no justification to make an order for payment of any common costs. And the judge, Mr. Justice Turner, agreed with the defendant's interpretation. So in that case, the wording of the original case management order may have made a very serious effect further down the line, many years down the line, in terms of costs. So negotiation and thought has to go in to the provisions that will be included in the initial case management order in group litigation, because that wording can be very, very important in determining how a case develops and on what terms. It's also important to bear in mind that individual Part 36 offers and a global call-to-bank offer aren't necessarily the only way to settle a group litigation case. In particular, it may be possible to make a group or a global Part 36 offer. And if that is possible, then obviously the advantages of that would be that a defendant making such an offer would have automatic costs protection, which isn't something which exists in a call-to-bank offer. That's simply an offer that the court will take into account. Whereas a Part 36 offer may, in effect, if it's not beaten at trial, mean that claimants don't recover any costs after the expiry of that Part 36 offer. There's only been one case which has considered the possibility of making Part 36 offers to more than one claimant, and that's the case of Arnie and Channel 5. Now, this was a case where a Channel 5 TV crew turned up on the doorstep of the claimants, filming them as they were being evicted from their homes for a programme called Can't Pay, We'll Take It Away. And the defendant made an offer during that case jointly to both claimants, saying we'll pay you £20,000 by way of Part 36. The claimants didn't accept that offer. They succeeded at trial, but they didn't beat the defendant's Part 36 offer. And the claimants argued, well, because it was a joint Part 36 offer made to multiple claimants, the ordinary costs consequences of Part 36 shouldn't apply. And the judge dismissed that argument and found that it was a valid Part 36 offer which had all the usual Part 36 consequences, meaning that the claimants were severely restricted in what costs they were able to recover. So that's another thing to give some thought to. Thank you very much for listening to our presentation today.